Good evening, everyone. So we had the fantastic news that Jed Wallace has again been dismissed from Lively's second amended complaint. This is great news, and Lively it's been dismissed without prejudice, which means she can refile, but she cannot do so in New York. So I was going to go through the order in a very condensed way. And then I was going to just give my own thoughts on where I think Lively is going to end up going next and why. So, defendants Jed Wallace and Street Relations Inc., the Wallace defendants, move pursuant to Federal Rule of Civil Procedure 12b-2 to dismiss the second amended complaint against them for lack of personal jurisdiction. The Wallace defendants also move for an order dismissing the claims against them under Rule 12b-6, or in the alternative for an order severing the claims and transferring venue to the United States District Court for the Western District of Texas. The motion to dismiss for lack of personal jurisdiction is granted. So, I'm not going to go too much into the background. Because it is just repeating itself. And the court itself says that the court will not now repeat the background. So, I mean, this is a 40-page order. I'm not going to read every part of it, but we'll just try and get to the pertinent parts. The court previously explained the allegations detailed below do not, at this stage of the litigation, reflect the court's own findings. So they go on to say about, the general allegations that concern sexual harassment and retaliation. It talks about the Wayfarer parties, etc., etc. And we don't need to cover that because we know all that. So he's basically sort of saying, look, Lively has said that New York is pertinent because the Wayfarer parties were in New York for press appearances. They were in New York when they initiated contact with Wallace about retaining him. Quotes Lively's various throwaway comments. And then he sort of says, well, while the Wayfarer parties were in New York during the lead up to the premiere, they also shared relevant information with Wallace about the public relations crisis, including Lively's allegations against Baldoni and Heath. These are currently, at this point, this is still allegations. So it's all of the ways that Lively quite hilariously tried to tie Wallace to New York, which were really scraping the barrel in some cases. Use of her Instagram posts, Elton John lyrics, and even the lyrics then weren't the actual lyrics of the song, as Chip Babcock eloquently pointed out. Wallace, he goes on to talk then about Wallace's response, which included, because Lively was asserting that Melissa Nathan lives in New York or works in New York, and Wallace included a declaration from Melissa Nathan, which said that actually, no, I don't live in New York. So there was that. Okay. Lively, for her part, has included a declaration with her memorandum of law in opposition to the motion to dismiss, purporting to demonstrate extensive phone communications between Wallace and Nathan on and after July 23rd, 2024. Again, I think that's more to do as you saying, well, Melissa Nathan, it was quite wild actually. Melissa Nathan lives in New York. Wallace knows Melissa Nathan, so therefore the court has pure personal jurisdiction over Wallace. And I found that such a confusing and bizarre argument. It was quite clear that that was going to fail. I don't even know why Lively paid her lawyers to make the argument. So he's gone over the procedural history, which is, this is when the action was initiated. This is the first amended complaint, and this is when the first amended complaint dismissed Wallace. And this is when we had the second amended complaint. So, firstly, in the original dismissal, the first dismissal, Lively did not argue that the Wallace defendants themselves had sufficient contacts with New York that would satisfy the long-arm statute. So the court rejected the argument for personal jurisdiction. That is the first time that Wallace was dismissed. So Lyman rejected Lively's initial argument that personal jurisdiction could rest on a theory of conspiracy jurisdiction. Sorry, just reading to see what I need to. They obviously talk about Rule 302. Lively had not pleaded that initially. Okay. Court also held that the amended complaint's jurisdictional allegations were deficient because there were no factual allegations that the Wallace defendants were aware of the torts being committed by co-conspirators in New York. Now, obviously, Lyman gave Lively leave to file the second amended complaint, which she did. That was just like a comedy skit, really. It was just like she'd done a load of psychotic paper cuttings out of newspapers of the weirdest, wackiest allegations and then plastered them into a document and called it a second amended complaint. So anyway, Lively did file the second amended complaint. Wallace then filed another motion to dismiss and Lively opposed it. And by September the 3rd, Wallace had filed his reply and the motion to dismiss was fully briefed. So, if we go through the actual decision based on the second amended, I just wanted to give a little bit of context on the lead up because there has been quite a lead up to this, just to kind of refresh a little bit. But so this is now regarding the second amended complaint. Firstly, we have personal jurisdiction. The Wallace defendants argue that the second amended fails to cure the deficiencies identified by the court in its first opinion and order, and they contend that the court therefore continues to lack personal jurisdiction over them. Now, I'm not going to go through all the legal standards. If people have questions, you put it in the comments by all means and I'll answer them. So in the second amended complaint, Lively identifies three separate bases for personal jurisdiction over the Wallace defendants. 1, conspiracy jurisdiction under Rule 302A2. on the theory that the Wallace dependents' co-conspirators committed tortious acts within New York in furtherance of the conspiracy, and that those contacts can be inputted to the Wallace dependents. 2. Personal jurisdiction under Rule 302A3 on the theory that the Wallace dependents committed a tortious act outside New York, causing injury to person and property within the state, that they expected or reasonably should have expected the act to have consequences in New York, and that they derived substantial revenue from interstate commerce. And 3. Conspiracy jurisdiction under Rule 302A1 on the theory that the Wallace dependents' co-conspirators transacted business within New York, and that those contacts can be imputed to the Wallace dependents. And then he finishes with, the court agrees with the Wallace dependents that Lively has failed to establish personal jurisdiction under any of these 3 theories. A lot of citations, so I'm just trying to get to the point from the judge that is specifically refers to his decision with Lively. Okay, so the Wallace dependents argue that Lively's 2 causes of actions against them, false light invasion of privacy, and aiding and abetting harassment and retaliation, both sound in defamation and thus are exempted from 302A2 and 302A3. The court agrees that the essence of these claims is injury to reputation, and that the claims therefore sound in defamation, and that the personal jurisdiction accordingly may not be predicated under either section of the long arm statute. So, false light invasion of privacy. Turning to the first claim, false light invasion of privacy, the second amended complaint alleges in relevant part that defendants publicly disclosed information or material regarding plaintiffs' marketing decisions, moral character, private life, and family, which showed Miss Lively in a false light. The false light created by the disclosures of these defendants would be highly offensive and objectionable to a reasonable person in Miss Lively's position, in that it made Miss Lively the object of scorn, pity, ridicule, humiliation, and other suffering. But to be honest, she should really think about suing herself for the scorn, ridicule, and just humiliation that she suffered in subpoenaing 107 content creators. I'm still quite bitter about that. I don't know if you can tell. These defendants knew the public discourses would create a false impression about Miss Lively, or acted with reckless disregard for the truth. As a direct and proximate result of the said publicity and false and misleading disclosures, Miss Lively sustained harm, including to her business and profession, as well as her reputation. Further, Miss Lively has suffered and continues to suffer from grief and anxiety as a result of the near overnight change in public sentiment regarding her reputation, work, and brands. As a further direct and proximate result of the said disclosures, Miss Lively has suffered loss of income and interference with future income. Okay. These allegations make clear that Lively's false light claim centers entirely on reputational injuries and harms flowing from those injuries. Not only do the allegations specifically and repeatedly focus on Lively's reputation, but they also refer more generally to public perception and sentiment and publicity. Moreover, the complaint directly ties the alleged economic harms to Lively's reputational injuries. Miss Lively has suffered loss of income and interference with future income. Lively identifies no harms associated with this cause of action that are divorced from reputational injuries. The court therefore has little difficulty concluding that this claim sounds in defamation. So you can't apply the long-arm statute where the claims at issue are reputational damage and therefore are what's called sound in defamation. So they're not defamation claims, but like false light, invasion of privacy is very similar, is predicated on a very similar basis and has similar consequences. There are differences in the legal standards, but it is similar in the sense of it is based on statements that are made publicly that are false and cause reputational damage. So Lively is saying, well, all of this, I suffered in all these ways, but all of the ways that she suffered are reputational. And the court is saying, well, you didn't identify anything that was non-reputational, no non-reputational harm. So therefore, you can't rely on this law. It specifically excludes these claims, these types of claims. So that is to summarize that part. I probably won't go into too much detail there because I can't see Lyman putting in anything cheeky or interesting, just being kind of factual and nonchalant. So then we have the aiding and abetting harassment and retaliation. And basically it's the same outcome. A similar conclusion holds with respect to Lively's claim for aiding and abetting harassment and retaliation in violation of California's FEHA. Although FEHA retaliation claims undoubtedly often have little to do with defamation, this is the unusual case in which the retaliatory acts identified relate exclusively to efforts to damage an individual's reputation and credibility. So the judge is saying here, this is not the norm. Normally, FEHA claims have nothing to do with defamation. But he is saying this case is different. It's the rare case where actually there is a bit of a crossover. So indeed, the only alleged adverse employment action that the complaint specifically identifies is the launching of a coordinated campaign to cast Miss Lively in a false light during the publicity and promotion of the film and thereafter. Lively's FEHA retaliation claim thus falls back on allegations regarding efforts to cast her in a false light. So even with the FEHA claim, the aiding and abetting harassment and retaliation, Lively is specifically linked false light, and the judge is saying, nope. I know, Mia's whinging at me, sorry. So the judge is applying the same rules as to the aiding and abetting retaliation and harassment claim as he has for the false light invasion of privacy. For the same reasons. The aiding and abetting section of the complaint further provides that defendants engaged in an astroturfing campaign to discredit and bury Miss Lively. These allegations likewise implicate exclusively reputational injuries and economic and emotional harms downstream from those injuries. In opposing the Wallace defendants' motions to dismiss, Lively has herself framed the aiding and abetting allegations as centered around efforts to damage her reputation. So he's saying, this was excluded, but yet you yourself have actually alleged, the excluded harm. So Judge does actually go on to say, indeed, the whole point of retaining the Wallace parties was so that they could help the Wayfarer parties shift the narrative from HR complaints on set to shining a spotlight on Miss Lively instead, in an effort to destroy her reputation. These harms all sound in defamation. So, everything that Lively is alleging that Wallace and Street did was all about damaging her reputation. She cannot bring claims under in Rule 302. So, and the judge just spends many pages explaining how nearly everything Lively has ever said or alleged is sound in defamation. Okay, let's move on to quiet. Let's see, right. So 302A1. Lively next turns to Rules 302A1, which permits a court to exercise personal jurisdiction over any non-domiciliary who, in person or through an agent, transacts any business within the state or contracts anywhere to supply goods or services in the state, so long as the cause of action arises from such business. Okay. As in her opposition to the Wallace defendants' first motion to dismiss, Lively contends that personal jurisdiction over the Wallace defendants exists under Rule 302A1 on a conspiracy theory of jurisdiction. In other words, Lively asserts that the Wallace defendants participated in a conspiracy, that their co-conspirators transacted business within New York, and that those contacts can be imputed to Wallace defendants. As the court explained in its prior opinion and order granting the Wallace defendants' motion to dismiss, New York courts have never applied such a theory of jurisdiction under Rule 302A1. Noting that such a theory was not necessarily inconsistent with the text of the long-arm statute, the court nonetheless declined to so hold. For even assuming that the conspiracy jurisdiction might exist under 302A1 in certain circumstances, Lively had alleged insufficient facts to establish personal jurisdiction on a conspiracy theory. The court once again reaches that conclusion here. Lively cites several potential overt acts that she believes constitute transacting business within New York, and which she argues can be imputed to the Wallace defendants. But these acts all fail to establish personal jurisdiction under Rule 302A1, as they variously were not completed in furtherance of the conspiracy, do not constitute transacting business under the long-arm statute, were not done with the Wallace defendants' awareness that conduct was being committed in New York, and rely on an improperly broad conception of conspiracy. First, Lively cites the fact that at least Baldoni, Heath, and Abel were physically present in New York when the Wallace defendants were invited to join the conspiracy. As Lively puts it, a key element of the business that the co-conspirators transacted in New York was hiring the Wallace parties to launch a social attack against Miss Lively. Most tellingly, for the purposes of this motion, based on Mr. Wallace's sworn testimony and information obtained in discovery, it is clear that at least Mr. Baldoni, Mr. Heath, and Miss Abel were all physically present in New York, promoting the film and responding to their perceived PR crisis that gave rise to the retaliation campaign when they recruited, met, and retained the Wallace defendants. That was the quote Judge Lyman is referring to from Lively's complaint. As an initial matter, it is unclear whether Lively has sufficiently alleged that the Wallace defendants were aware of their alleged co-conspirators' presence in New York at the time. Lively relies primarily on allegations that Wallace was retained to engage in observation and analysis of social media related to the film, and that certain social media posts, including one from Baldoni himself, indicated that he was heading to New York for a full week of press for the It Ends With Us movie. Lively also observes that certain co-conspirators replied to messages from a, quote, East Coast time zone. Even assuming, however, that Wallace was monitoring social media and assuming he was doing so methodically, that still provides a weak basis for concluding that he was personally aware of the entire range of posts related to the film, including all those from Baldoni. Moreover, as the Wallace defendants point out, that certain messages come from Eastern time zone hardly evinces that co-conspirators were in New York as opposed to one of the other 22 states in that time zone. That was wild. That was really wild, and I loved Charles Babcock's clapback to that. But regardless of the Wallace defendants' ultimate knowledge, the fact that they were hired while their alleged co-conspirators were in New York for the film's premiere does not constitute transacting business within the state. Under New York law, the transacts business standard can be satisfied where both the negotiations and the execution of a contract took place within New York. Likewise, the fact that the Wayfarer parties were temporarily in New York when they engaged the Wallace defendants to join the conspiracy does not demonstrate purposeful availment of the benefits and protections of New York's laws. Baldoni, Heath, and Abel, all California residents, were in New York for a period of a few days to attend the premiere, not to establish any business relationship with Wallace. Moreover, at least Abel left the state the day after the premiere. It was therefore merely coincidental or fortuitous that the agreement was executed while they were still physically present in the state, as opposed to elsewhere shortly after. Importantly, there are also no allegations that the contract contemplated performance in New York. The complaint instead alleges that Wallace and Street are based in Texas and California, and that certain people working for them are based in Hawaii. Got a footnote here. Okay, so Lively, right, okay. Yeah, it's just about where Wallace's staff worked. To be sure, the fact that the Wallace defendants were hired while the Wayfarer parties were in New York was not wholly unrelated to New York. The premiere was in New York. Baldoni was in the state when he learned that his co-stars refused to appear alongside him at the premiere, and that knowledge at least partially prompted Wallace's hiring. But simply some connection to New York is insufficient. And considering the circumstances, this was not fundamentally a New York business transaction. Rather, it was an agreement between out-of-state parties, some of whom happened to be temporarily in the state, concerning out-of-state work. In her opposition papers, Lively states that as part of engaging the Wallace defendants, a New York resident then in New York shared all the info with Mr. Wallace. The second amended complaint, however, does not allege that Case was then in New York. So that's Catherine Case, is it? And even if it did, there are no allegations indicating that Wallace knew she was a New York resident then in New York, such that her contacts could be imputed to him under a conspiracy theory of jurisdiction. The same goes for the second amended complaint allegations against Nathan. Maintained a residence in New York during a portion of the relevant period when she helped Wayfarer retain the Wallace defendants. Even if Nathan did maintain a residence in New York around the time of the premiere, she has denied that she lived in the state at the time. The second amended complaint alleges neither that she was physically present in New York when the Wallace defendants were retained, nor that Wallace had reason to believe she was. In fact, the second amended complaint suggests the opposite, as Nathan apparently messaged Abel that Abel could have stayed at Nathan's apartment during the premiere. Nathan confirms in her declaration that she was not in New York for the premiere. Separate and apart from the issue of retaining the Wallace defendants and whether that satisfies Rule 302A1, the second amended complaint states that because Wallace remained involved in closely coordinated work with the other defendants from early August 2024 at least into early 2025, it is implausible that he would not have learned during that time, and certainly prior to the filing of the retaliatory lawsuit and the construction of the related website, that Miss Case and Miss Coslow were New York residents actively transacting business in New York on behalf of TAG, and otherwise in order to perform numerous overt acts in furtherance of the conspiracy. This reference to Wallace's awareness of Case and Coslow actively transacting business in New York in order to perform numerous overt acts in furtherance of the conspiracy is wholly conclusory and simply parrots the statutory requirements. Without providing any facts regarding what this transacting business entailed, there is no way to determine whether Wallace was plausibly aware of the acts such that they could be imputed to him. Lively next relies on the fact that while the Wayfarer parties were in New York for the film's premiere, they promoted the film and made associated press appearances. These contacts also failed to satisfy 302A1 under a conspiracy theory of jurisdiction. Assuming arguendo that they might constitute transacting business under 302A1, they can hardly be said to have been done in furtherance of the conspiracy, given that they no doubt would have occurred in the normal course of the film's release, regardless of the conspiracy's existence. Furthermore, Lively asserts that these appearances were part of conducting the very communication strategy of which the Wallace defendants would become an integral part. But she does not identify how they were used or would be used to harm her reputationally. They thus were not acts in furtherance of the conspiracy. For example, the second amended complaint references an appearance on the Today Show which films in New York, but says nothing about who made that appearance, what was said, or how that appearance might have furthered the objectives of the conspiracy. The complaint further alleges that Baldoni has engaged in stunning duplicity, praising Miss Lively to her face and in public while secretly disparaging her in private and plotting to bury her alongside the truth of his own behaviour, which suggests that the Wayfarer parties did not in fact use the public press appearances, at least not initially while in New York, to tarnish Lively's reputation. So that's interesting. So the judge is saying, hold on a minute, Lively. You're saying that they did this press tour to tarnish her reputation, but you're also saying that Lively was showering you with compliments to the press. He's basically saying, make it make sense. Because Lively has not alleged facts to support the inference that the Wayfarer Party's promotion of the film in New York was conducted in furtherance of the conspiracy, she has also failed to demonstrate that her claims arise from these contacts, which 302A1 separately requires. Shifting gears, Lively asserts that the Wallace defendants and others were involved in the creation of a website for public view designed to manipulate public opinion relating to the Wayfarer Party's allegedly retaliatory New York-based litigation. There is no allegation that this work was performed in New York. The argument instead seems to be that creating a website with information or statements about a New York-related subject matter and which is accessible in New York is enough to establish personal jurisdiction under 302A1. It is not. New York case law establishes that making defamatory statements outside of New York about New York residents does not, without more, provide a basis for jurisdiction, even when those statements are published in media accessible to New York readers, such as a website. Lively has not sufficiently alleged something more than the publishing of the website. She has not alleged, for instance, that the website was prepared, researched, or developed in New York, or that it was specifically designed to target New York residents. To the contrary, the second amended complaint suggests that the website was intended for a national audience and designed to spread a narrative about the lawsuit as broadly as possible. The website's low level of interactivity also counsels against finding the transaction of business. The site merely posts online for public consumption certain documents filed in connection with the Wayfarer Party's lawsuit, including annotated text messages and a winding self-serving chronology from prior to the film's production through the filing of Miss Lively's complaint in order to advance defendant's narrative. It does not seek to exchange information with users or to initiate commercial activity. The second amended complaint's allegations regarding the website therefore failed to establish personal jurisdiction. Finally, Lively invokes the Wayfarer Party's allegedly retaliatory lawsuit filed in this court as a basis for establishing jurisdiction under Rule 302A1. She argues that, although the Wallace defendants were not parties to that suit, the filing of the case was an overt act in New York in furtherance of the conspiracy, and which occurred with the Wallace defendants' awareness and support. This asserted basis for personal jurisdiction presents the closest call. The second amended complaint sufficiently alleges that the Wallace defendants were aware of the suit and that it would be filed in New York. Furthermore, taking as true Lively's allegations that the lawsuit was retaliatory and intended to advance the smear campaign by further harming her reputation, the filing of the suit would appear to fall within the scope of the conspiracy, and her claim at least partly arises from that conduct. Additionally, although Lively has not cited any authority to this effect, courts have held that litigating a case in New York can, under certain circumstances, constitute purposeful availment of the benefits and protections of the state's laws, sufficient to establish personal jurisdiction under 302A1. Ultimately, although certain defamation claims may be brought under 302A1, even when they may not under A2 or A3, Finding jurisdiction in this case would be inconsistent with the legislature's goal of preventing disproportionate restrictions on freedom of expression. That is because Lively's position requires an expansive interpretation not only of transacting business but also of conspiracy jurisdiction under 302A1. New York courts have held in the context of 302A2 that conspiracy jurisdiction requires that the in-state co-conspirators acted at the direction or under the control or at the request of or on behalf of the out-of-state defendant. As the court explained in its prior opinion and order, the New York Court of Appeals has never addressed whether this requirement of directional control may be satisfied by a co-conspirator's mere awareness of the relevant in-state act. The Second Circuit has predicted, however, that if the New York Court of Appeals were to address that issue, it would hold that mere awareness is sufficient. Although that prediction stands in some tension with more recent New York cases requiring the out-of-state defendant to have some extent of control over the in-state actor, the court continues to believe itself bound by the Second Circuit's decision in Fat Brands. Nonetheless, the Second Circuit has never held or even suggested that this prediction likewise applies in the 302A1. So the judge is saying, that where there's a requirement of directional control, that would be satisfied by the co-conspirator's mere awareness of, like in this case, Jed Wallace's mere awareness of, say, Coslow and Case being New York residents, for instance. That would work under Rule 302A2. The courts have already held that. 302A2 does not work, obviously, because of the sound and defamation basis. So the judge is looking at this point at 302A1, and he's saying, well, this has been the closer argument, but because mere awareness has never been held or even suggested, that he is not applying it in the same way that he would have applied it potentially to 302A2. Right. Finding personal jurisdiction in these circumstances would therefore require not one but two significant extensions of New York law without direction or guidance from New York courts or the Second Circuit. Lively is asking not only for this court to apply conspiracy jurisdiction under 302A1, but for the court to transplant wholesale a contested and developing area of law involving the requirements of control and direction in agency relationships to a new context involving distinct considerations. Indeed, whether and to what extent an agency relationship must be demonstrated under Rule 302A1 makes a difference in this case. The Wallace defendants are not alleged to have directed, controlled, or requested that their alleged co-conspirators file a lawsuit, nor are the Wayfarer parties alleged to have filed the suit on the Wallace defendants' behalf. If anything, it's the other way round. The complaint alleges that the Wayfarer parties utilised the Wallace defendants as their agents for the purposes of the retaliatory scheme. Accordingly, The court cannot apply conspiracy jurisdiction under Rule 301A1 without addressing the issue of direction and control. Exercising personal jurisdiction over the Wallace defendants based on such a broad conception of agency and conspiracy would be inconsistent with free speech considerations and New York court's instruction to apply 302A1 narrowly in defamation cases. Consider a hypothetical scenario in which several individuals loosely organize themselves online for the purpose of promoting an issue of public importance, say, to bring public and government attention to an alleged defect in a popular consumer product. The individuals are scattered across the country, save for one located in New York, and they research, write, and publish posts in their respective states that are accessible online in New York. It is clear that 1. The individual located in New York may be subject to suit in New York on claims of defamation or product disparagement, and 2. That the out-of-state individuals are protected under Rule 302A2 and A3 from being hauled into a New York court based on their out-of-state utterances, even if those utterances are accessible online in New York and concern a New York resident. Every time I speak, Mia is kind of whining. Are you trying to talk? Yeah, I think she's showing her displeasement with Blake Lively. Okay, now I've lost where I am. Thanks for that, Mia. On Lively's expansive theory of 302A1 conspiracy jurisdiction, however, those same out-of-state individuals could be sued in New York so long as the plaintiff plausibly alleged that they were aware of the New York-based members' purposeful activity in New York in furtherance of their shared end, even if they had no direction or control over that activity, and even if it was not necessary to their own out-of-state activities. Applying 302A1 in those circumstances would effectively permit an end run around the statutory defamation exception, opening New York courts up to a vast array of out-of-state defendants. So he's basically saying, well, look, Rule 302A2 and A3 do not apply to defamation. But what you're wanting us to do here with the transaction, the business transacting element, the conspiracy, is apply a rule that would basically give it like a backdoor way to bring in defendants who would potentially face action in New York from defamation, but they would be excluded under these two parts of the rule. But you're wanting me to change the rules so they could be brought in on another part of the same rule. And he's saying, I'm not doing that. The Wallace defendants' own contacts with New York are insufficient to constitute transacting business under Rule 302A1. There is no allegation that they had any role in the Wayfair Party's decision to file a lawsuit in New York, let alone direction or control over that decision. The fact that the lawsuit was filed in New York was only incidentally related to their involvement in the conspiracy. Their alleged conduct would have been no different had the lawsuit been filed elsewhere, or had the allegedly defamatory statements been made through a vehicle other than a lawsuit. Yet because the Wallace defendants were aware of the lawsuit, and because the lawsuit was one of the means of conspiracy, even though not one in which they were directly involved, they would be subjected to personal jurisdiction in the state. Such an approach would unjustifiably extend the intendment of the legislature to allow in limited circumstances, the reach of this state's jurisdiction beyond its border in defamation cases. Lively has therefore also failed to establish personal jurisdiction over the Wallace defendants under Rule 302A1. Because the second amended complaint fails to establish personal jurisdiction over the Wallace defendants under New York's long-arm statute, the court need not address the parties' due process arguments. Furthermore, in light of the court's disposition of the motion to dismiss for lack of personal jurisdiction, the court does not address the Wallace defendants' arguments that the second amended complaint fails to state a claim for relief or that venue should be transferred. The Wallace defendants' motion to dismiss the second amended complaint for lack of personal jurisdiction is granted. The second amended complaint is dismissed as to the Wallace defendants without prejudice to refiling in a court that has personal jurisdiction. And I said at the start I would give an opinion on what I think Lively is most likely to do next, and why. And I've seen a lot of people who say, take the word in quite literally, refiling in a court that has personal jurisdiction. And people are looking at it and saying, well, that's clearly going to be Texas because, Jed Wallace and Street, Jed Wallace lives in Texas, Street is incorporated in Texas. I do not think that's what she will do next. I'm not saying she might do, but my personal guess is no, I don't think she's going to, because she's trying to get dismissed for lack of personal jurisdiction in Texas now. Jed Wallace filed a lawsuit against her before she added him to her New York complaint, because initially it was just the Wayfarer parties, and she added him, some weeks later. Well, before she added Jed Wallace beat her to the punch and filed a case in Texas against her, and she has been fighting tooth and nail to get herself out of Texas because the laws there are not particularly favorable to her. So I do not think she's voluntarily going to go to Texas. Now, one of the things I noticed in one of her motions to dismiss, she actually sets the foundations for an argument that California is the right venue. She's predominantly arguing for New York. That's probably not going to hold weight, because now Judge Lyman, I'm sure Jed Wallace will take this ruling and say, well, hold on, Judge Lyman has already said he doesn't hold personal jurisdiction over me, so, Texas judge, do not send this over there. But she has already kind of put some groundwork in that California would be potentially a better venue if New York fails. And there are a couple of reasons for this. Firstly, at the time Jed Wallace was hired by Wayfarer, at the time of the alleged retaliation, Jed Wallace was living in Texas, but Street was incorporated in California. It only moved its corporation to Texas after the lawsuit was filed. Because Brian Friedman was the attorney who oversaw that, and Lively made a big fuss about that. I'll actually go and have a look. Bear with. Okay. Right, so I got it. So I'll share the tab. So this is the Articles of Incorporation. This is it's a certificate of conversion. Is this the right one? Oh, sorry, had the wrong one. That was a document transferring it to Texas, and that was dated the 6th of February, the same day as the conference, the first ever hearing that we had. So this is actually the Articles of Incorporation of Street. Mia, sorry about her. It was a California incorporated entity. Jed Wallace formerly lived in California. Now, he did move to Texas some years ago, but he did not convert street relation to Texas until, let me just check, I've got the right one. So I'll pull this back up now. He did not convert, now I'm waiting for a download. Street relations. This was filed, as you can see at the top, the 6th of February 2025. And this address, 1801 Century Park, that is the address of Brian Friedman's law firm. And Lively made a huge deal about it in her motion to dismiss Jed Wallace's amended complaint. This is where these filings actually are. So I think, I don't know whether she might just go for street on its own as an entity and make a claim, because technically it was street that was hired. Jed Wallace is at the helm of street relations, and she could plausibly argue that at the time of the alleged harm, that street was a California incorporated business. It would be much stronger than anything she's tried for New York. Also, her clients, Wayfarer, the company, is a California incorporated company. Baldoni, Heath, Sarowitz, it's Baldoni and Heath and Abel, and I believe Melissa Nathan is also California residents. And, you know, she could say, well, she was acting for these clients who are based in California. The company, his own company, Street, was a California entity at the time. That is far more stronger than you know, her effort to try and bring him into New York. But also, from the Texas standpoint, it's equally as strong, in my opinion, because we got if you look at the time of what the retaliation when Jed Wallace was actually hired, the company Street Relations was incorporated in California, and that is, you know, as strong as saying, well, Jed Wallace is a Texas resident. It's just my opinion, but I think she is more likely to go try California than she will Texas, because I know she really doesn't want to go to Texas. And then she could use the Blue Jean Baby in its correct format with the California lady, when she, you know, has to then make the argument that California applies. It's a hypothesis. She might not even bother to refile. You know, that is possible too. But I do think, I think Texas would be an absolute last resort, because if she goes to Texas now and then claims that Texas has got Wallace, personal jurisdiction over Wallace, then that just contradicts all the claims that she's been arguing, that, you know, that the Wallace case should be actually transferred out of Texas. Like, Wallace is saying, you know, rightly so, that Texas has jurisdiction over him. And he is right because he is a resident. But Lively has already made the argument in that lawsuit. Well, Street, though, is a California registered company. And that is why I think that she is going to go try California. My opinion, it may come to nothing. She may surprise me and actually just go straight to Texas. I don't know, but we will see. So that is the wonderful, wonderful news that Jed Wallace has finally left the New York Second Court building. He is no longer in the lawsuit. As far as New York goes, I think that will harm Lively's claims against Wayfarer for the retaliation. Why? Because Lively has not alleged that any of the Wayfarer parties knew how to do a global, digital retaliation. They had an army of bots who were able to do this smear campaign. That is why they paid, as she points out, a lot of money to Jed Wallace. He's the expert. He is now dismissed from this lawsuit. So, whilst she can still say, well, they hired Jed Wallace, and technically he has only been released for lack of personal jurisdiction, the judge himself has also found on a couple of points, I've said to Lively in his motion to in his order dismissing Jed Wallace this time, he has pointed out a few contradictions in Lively's narrative, and I'm here for it. It's about time, but at least he has done that. So yeah, we will see how this goes. But also, this obviously takes him out, so now he will not be in the motion included in her motion for summary judgment, etc., etc. Because I was asked this earlier. If he's not dismissed by a time of motion for summary judgment next week, will she, include him? Yeah, and I did say yes. And then about half an hour later, I had the ping to say that the order was up. So he will now no longer be part of anything to do with her motion for summary judgment, which is great news. All right, I'm going to leave it there because I've gone on for quite a while. Sorry, this was a long document. I will catch you in the next one. Have a good evening.